open the broadcast with the big development as far as the Supreme Court verdict on child pornography is concerned. A three-judge bench sets aside the Madras High Court judgment. In fact, the Madras High Court committed an error is what has essentially been stated. Let's also tell you the Supreme Court has said watching, storage, child porn offence under POCSO. So that's the big development as far as what the top court has said. Essentially, watching and storage of child porn is a crime under POCSO. In fact, the CJI said this is a landmark judgment. The Supreme Court has now suggested Parliament to amend the term child pornography as well. So significant takeaways from this. One, let's tell you that the Supreme Court says watching and storage of child porn crime under POCSO. CJI has also said this is a landmark judgment. The Supreme Court has also suggested the Parliament to amend child pornography. That is the term. And the Supreme Court says courts must not use term child porn. In fact, the Supreme Court has gone on to state, replace child porn with child sexually abusive material. So very important details that is coming to the fore. Harish Nair, my colleague, joins me with more details. Harish, very good morning. Significant development is as far as the Supreme Court verdict that is concerned. Tell us a quick takeaway of the same.
Yes, landmark judgment as termed by the Chief Justice of India, Chandrachud Nivedana. As you rightly said, the Supreme Court has ruled that downloading, watching child pornography is also an offence under the POCSO. This apart from creating, publishing and disseminating to storage, even storage for viewing the child porn is also been termed as an offence by the Supreme Court. Supreme Court has said Madras High Court has committed a very serious error in ruling that downloading and watching is not an offence. Saying so, the Madras High Court had acquitted an accused who was booked under the IT Act and provisions of IT Act and the POCSO. Very significantly, Supreme Court has restored the criminal proceedings against this particular individual, this accused. Now the trial will go on against him once again. Supreme Court has restored criminal proceedings against a man acquitted by the High Court despite downloading and watching child porn. Centre has been asked to bring in amendment in the POCSO to replace word child pornography with child sexually abusive and exploitative material, and courts, all courts, including High Court and lower court, have been asked to enforce, stop using the word child pornography. So it's a landmark judgment. Supreme Court has held that mere storage of child pornographic material is an offence under the Protection of Children from Sexual Offences Act. Remember, this Supreme Court had set aside Madras High Court order that said that mere downloading and watching child pornography is not an offence. Remember, several child rights NGOs had moved to Supreme Court against the Madras High Court ruling that downloading and watching, storing, downloading and watching child pornography is not a crime. Even earlier during the hearing, Supreme Court had said that the Madras High Court judgment is atrocious, and the Chief Justice said that apart from creating, publishing and disseminating, even use of children for making pornographic videos is also an offence. So all these are an offence. Supreme Court coming down heavily on using children for manufacturing porn videos. Supreme Court was pronouncing its judgment in an appeal against the Madras High Court order, holding that merely downloading or watching child pornography on one's electronic device did not constitute an offence. This is Pardiwala said, we have said on lingering impact of child pornography on victimization and abuse of children. We have said on role to report under section 19 and 21. We have also laid down certain guidelines. So all these guidelines will be in the detailed judgment which will be uploaded by afternoon. Back to you.
Right, Harish. Thank you very much for taking us to the key takeaway as far as this landmark judgment stated by the CJI is concerned. Having said that, we leave it at that for the moment. We now